Hi, this is Manuel Wilhite with my presentation for Internet and the Law, Week 4 assignment, Terms of Service. The first question is, do you think that the agreement is a valid contract? And I do think this agreement is a valid contract, but it depends on the context and the validity it is used with. When examining the concepts of click wrap versus browse wrap, one can see how usage of the site can change the obligations there are to abide by the terms set forth. In a court decision, in the case of Nugent versus Barnes & Noble, it was found that a user was not obligated to follow the terms just because a link was available to them. Click wrap, on the other hand, is designed for the user to affirmatively agree to the terms. In the browse wrap example, the terms are not enforceable, while the click wrap example, the agreement is legally binding, except where superseded by federal and state laws. The second question is, does it matter whether a visitor affirmatively assents through clicking I agree icon or something similar, or should a user be bound solely through the use of the website? An example, especially if the user has not read it. A user, once they click the I agree button, is bound by the terms they have presumably read while completing the registration process. It is important for site owners as well to stipulate all terms in that registration process, as they propagated messages concerning the terms are not valid. In the case of Schnabel versus Treligent Corporation in 2012, the site owner was told that sending more conditions of the terms of agreement in an email after the registration was not enforceable. The case went on to clarify that for an electronic signature to be effective, the button clicked must show the user's intent to comply with the terms put forth. So it does matter. Once a user clicks I agree, they are then entered into that contract. What are some of the user's obligations under the terms of agreement? For the terms of agreement to be accepted, a user must comply with certain requests as dictated by those terms. Throughout these terms, there are multiple areas where the user is to adhere by certain stipulations. Among those are the Section A requirements. Section A requires that users respect the copyright as well as follow certain steps to claim copyright infringement. As an example, to claim infringement of a copyright, a user must identify the works infringed on, prepare a good faith statement noting their concern, prepare a truthful statement and acknowledge liability for untruthful statements, and be executed by a party authorized to act on the user's behalf if the user doesn't do it itself. Section C requirements say that the user is to adhere to certain stipulations to use the site. Some of those requirements are not to copy the content, not to deep link to the site, and not to scrape data with automated tools such as bots. Also, they are not to perform unlawful activities such as credit card fraud, and they are not to post unlawful content. Section R requires that a user not engage in any form of linking for commercial purposes. It also states that in order for a link to be granted, the user must obtain express written permission for the site owner. Section R also states that only link Section R states that the only link to the site should be the home page, and even then, it is only for personal use. Section Q states that all international users must adhere to the requirement for such users. It says that any users from outside of the USA must consult with a list of countries provided by the site. Those users not from those countries listed are not advised to use the site. It's important to note that these rules only apply when a user enters the contract once I agree has been clicked. Question number 4. Does Priceline have any obligations under the agreement? Priceline.com is bound to FTC statutes regardless of the terms in the clauses of their agreement. They are also bound by the terms of agreement they adhere to once fees from credit cards are accepted. In an example, the Priceline Group Incorporated and Hilton Worldwide Incorporated were sued in a proposed hidden fees class action filed in a Connecticut federal court. The suit contends that there were hidden fees undisclosed at the time of the agreement. The lead plaintiff, Adam Singer, had the position that the slogan, "Name Your Own Price," was in violation of an FTC statute that protects consumers from misleading offers. So even though the terms state they absolve themselves from any claim to warranties, including claims of their trademark slogans, the federal law supersedes their terms as set forth in the agreement a user clicked "I agree" to. Question number 5. Are there any statements in the agreement you think are unenforceable? If so, why would the company put those provisions in the agreement? If a minor uses the site, that most likely cannot be enforced. The minor may even use their parent's credit card without permission. This is something the site cannot enforce, but to cover themselves, they stipulated that minors under 18 cannot use or make changes to information already entered. They include this to absolve themselves of liability in the event it does happen. This is not to say that a minor cannot be bound to a click-wrap agreement, though. As an example, a district court dismissed a plaintiff's claims against Facebook. They said that because the minor entered into the agreement set forth in the terms that they were bound. They also said that the agreement was voidable, but the minor did not opt out when they had the chance. They stated their findings as such. In California, there is a basic presumption that minors can enter into binding contracts except as provided in Section 6701. This section prohibits a minor from giving a delegation of power, making a contract relating to real property or any interest therein, and making a contract relating to any personal property in the minor's immediate possession or control. Question 6. What changes would you recommend to the agreement? I would change the way the terms of agreement open. Best practice dictates that the first section of a terms of agreement address the usage of the site as acceptance of the terms of use. Priceline starts theirs with copyright information and covers usage further down in the agreement under Section C. They should also add a section that states specifically what to do with complaints similar to the statement of copyright infringement. As an example, the Twitter profile, twitter.com/negotiate or dead, is a private profile dedicated to complaints about Priceline.com. Their users are all mad because of unsatisfactory experiences. To address a grievance process in the terms of agreement might save them litigation if it can be shown the user had a process to follow that was pre-prescribed. Thank you for joining me for this presentation, and stay well.